This may look like a routine plea and sentencing hearing, but don't let the calm tone fool you. This is a moment where someone's entire future is being decided in minutes. The defendant, Enrique Soraniano, is facing a third-degree felony, DWI, meaning this isn't his first time here. The stakes? Up to 10 years in prison. What's about to unfold is a tension-filled balancing act between punishment, rehabilitation, and family responsibility. The court must decide whether community supervision is appropriate or whether past failures on probation outweigh present circumstances. Layered into this case are mental health struggles, family caregiving responsibilities, prior probation violations, and substance abuse treatment recommendations. Watch closely, because this judge isn't just listening, she's weighing credibility, risk, and public safety. The question that hangs over this entire hearing is simple but powerful. When someone has failed probation before, how much grace should the court give the second time around?
Review the PSI and TAP evaluation. State?
Yes, Judge.
Defense?
Yes.
Any objection? State?
No, Judge.
Defense?
No objections to it.
All right. Anything you wish to say on behalf of your client?
Would you explain to you're applying for probation? Is that right?
Yes, applying for probation.
And tell her about your family and what's happening with you.
So back in November, my wife.
Well, you want to raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right. You can lower your hand. State your name for the record.
Enrique Soraniano.
All right. What would you like to say?
So back in November, my wife lost her grandpa, and she was having like breakdowns. So she got prescription medications, which is I think like escalates. So she was taking that for a couple weeks, and then she had like a screening for a hernia. So she had stopped taking them for the whole week. That caused her to get a mental illness. So she had to get hospitalized at the specialty transplant hospital for psychosis and bipolar 1. So that caused a whole bunch of stuff. She can't drive. I have to take care of her basically. And she relapsed.
This is the formal legal groundwork being laid, and it matters more than it sounds. The judge confirms that the defendant understands everything: the indictment, the plea, the rights he's waiving, and most importantly, the punishment range. A third-degree felony DWI carries serious consequences, including prison time, fines, and long-term supervision. When the judge says she does not have to follow the plea agreement, that's a critical warning. Even if both sides agree on probation, the court retains full discretion at sentencing. This moment ensures the plea is legally valid and protects the record from future appeals. For viewers, this is a reminder. Plea deals are recommendations, not guarantees. Would you feel comfortable entering a plea, knowing the judge could still impose something harsher?
I'm the one taking them to school, picking them
Your
up.
problem is that they're asking for inpatient treatment. That's what we need to get to the point. So what you're giving me is reasons why you don't want to do inpatient treatment, but it's not addressing the underlying problem, which is they say you need inpatient drug treatment.
Judge, if I could.
Excuse me, we're on the record.
I would hope that you could give him intensive outpatient treatment and hold that other in abeyance, because I think he's going to do well with that, but he's got to help his family. He's got to be there for them.
State?
State agrees with the recommendation of the supervision department.
All right, the recommendation says inpatient treatment, or they say I could consider intensive outpatient treatment. How many children do you have?
I have 2 year-old,
What are their ages?
8 and 6.
And what is your work schedule?
Tuesday through Saturday, 10 to 7.
That's 10 a.m.
Yes, ma'am.
to 7 p.m.?
Yes, Judge.
All right, so who's looking after the children during those times?
My wife is.
So, I
Yeah.
mean, he trusts her to look after the children from 10 a.m. to 7 p.m.
Do you have any other help with you?
We do have a support system, yes.
Who's your support system?
So family members, family friends, we recently moved, so my brother's down the street now. But it was very intensive as far as like getting her stabilized. So we have been seeing her psychiatrist, on a monthly basis. So she's really stable. So she's able to watch the kids. She's not a danger to herself or anyone around her. It was just the relapse. She still can't drive and none of that.
And see, the problem is you've been on probation before for DWI. And there's a motion to revoke file. And you were continued. And then you were terminated unsatisfactorily. Is there anything else?
Judge, that's what we're asking for. It's an outpatient.
All right.
Here's where emotion meets reality, and the judge cuts straight to the point. The defendant's testimony is heartfelt and detailed. A spouse struggling with severe mental health issues. Children depending on him, financial pressure and caregiving responsibilities. But the judge refocuses the discussion on the core issue, substance abuse treatment. From the court's perspective, sympathy does not resolve risk. The supervision department is recommending inpatient treatment, not as punishment, but as a response to repeated DWI behavior. The defense argues for intensive outpatient treatment to preserve family stability. This exchange highlights a hard truth of sentencing hearings. Personal hardship explains behavior, but it doesn't excuse it. The judge must ask, does this defendant need flexibility or structure so strict that it disrupts his life to prevent future harm?
So she's really stable. So she's able to watch the kids. She's not a danger to herself or anyone around her. It was just the relapse. She still can't drive and none of that.
And see, the problem is you've been on probation before for DWI. And there's a motion to revoke file. And you were continued. And then you were terminated unsatisfactorily. Is there anything else?
Judge, that's what we're asking for. It's an outpatient.
All right, this is what the court is going to do. The court is going to sentence you to 4 years in the prison, suspended and probated for 4 years. There's to be regular reporting by Zoom or in person. Excuse me, you all are blocking probation.
The court's ruling reflects a careful compromise. The defendant receives 4 years in prison, suspended and probated for 4 years, meaning incarceration is avoided, but only under strict conditions. This sentence is packed with accountability. License suspension, ignition, interlock, drug testing, treatment requirements, community service, parenting classes, felony drug court, and close supervision. And this is not leniency, it's structured pressure. The judge clearly considers the defendant's family obligations, but she also weighs prior probation, failure, and public safety. The broader takeaway: second chances come with tighter reins. The system isn't just punishing, it's watching closely. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.